for having me. As he said, my name is Zachary Heck. I'm an attorney with the law firm of Taft, Stettinius, and Hollister in Dayton, Ohio. And my practice is primarily centered around privacy and data security. So working with companies at all stages of the data life cycle, whether it be from developing a data governance program, and I'll talk a little bit about what that means shortly, to policy development, training, drafting those terms and conditions, helping companies navigate through different regulations that they're covered under, litigating against claims from whether it be from consumers, whether it be investigations from state attorney generals or from the Office of Civil Rights, really that kind of a practice, and of course in the aftermath of a data breach or a security incident, helping the client navigate through those notification requirements and so on and so forth. I'm a professor at Wright State University where I teach in the engineering department with respect to legal aspects of cybersecurity, and I'm also a high school mock trial coach, which I've been doing for about a decade now. It's one of my passions, something that I love to do, and it's a way I give back to the community. And so to talk about this idea of transparency and making people aware of how their data is used and why it's used, one of the things that I thought would be helpful to begin with is how I initially counsel clients with respect to getting a sense of what data they have and what they do with it. So the first step when I counsel a client is getting a sense of data classification. You can't govern what you don't understand. So getting a sense of defining the data that a company collects in external terms. For example, personal identifiable information, our names, ages, dates of birth, addresses, email addresses. All that information is valuable, has value out there. Certainly Social Security numbers, a hot button issue. Protected health information, if you're a covered entity under HIPAA, whether you're a provider, you're a healthcare clearinghouse, you're a health plan, you have to comply with the ins and outs of that federal regulation. And you're accountable to the Office of Civil Rights. So that data, if it gets out, if it's misused, if it's improperly disclosed, there's a heightened risk. Non-public personal information, financial institutions, regulated under the Gramm-Leach-Bliley Act. So that's information that you've given to your bank or to your credit union, certainly having different risks if that were to be improperly disclosed or if that were to be leaked out onto the dark web. And then other types of information, maybe not identifiable to the individual, but certainly with value, trade secrets, patentable information. All of those examples of information have value. They're all important, but they're important for different reasons. And there's different risks of liability attached to improper disclosure for each of those. And so, when I talk to clients, I ask them to look at the information they collect, and once they've identified it, rank it in terms of risk. So you could do that with high risk, medium risk, low risk. If you are a covered entity under HIPAA, and you have patient records, you have x-rays, you have social security numbers, all of that information is high-risk information. Whereas the tweets that you plan to send out next month or the new ad campaign that you hope to launch in a couple months, yeah, there's harm if that gets out, but it's certainly not as harmful as the patient records. So maybe you identify that as low risk, or maybe we think about this as level 1, 2, and 3. Or we think about in terms of this is confidential, this is highly confidential, this is proprietary, this is public. And with that information, with that planning, then the company can better allocate its resources to safeguarding that information. They can do a better job of figuring out, okay, we have this much in the budget with respect to data governance and security. We're going to allocate it based on that risk. So once you understand the data that you have, then I ask them to map that data and figure out exactly where they keep the information. Map the existing locations where personal identifiable information or protected health information is. And you can do that in one of two ways. Technical locations, such as which databases, which servers, which systems are housing this information, versus physical locations. Do you keep it in a locked drawer? Do your employees keep all this information just out on their desks, scattered about? Is it in different office buildings or different floors within the same building? Getting a sense of where it's located, because you can't govern what you can't locate. So getting a sense of all that. And once you have those answers, identifying what you have and identifying where it is, then you can better protect it. And so the same rings true as individuals. Figuring out what information we have and identifying where we give it out. So I'll give you an example. Last year I got married. That's my wife, Jennifer, on the left. And when I proposed, I didn't know anything about engagement rings. Nothing at all. And so I spent hours and hours researching online because I'm a lawyer. That's what we do. We study for fun. And I learned everything I could about engagement rings. I'd go from website to website, online store to online store, trying to figure out exactly what makes for a good engagement ring. And about a week before I proposed to Jenny, I was online, and she looked over at my screen and saw all of these ads on the side of my page for engagement rings or wedding information or engagement photos, all of this wedding and engagement themed advertisements. And she said to me, "Zach, why do you have so many ads for wedding and engagement type stuff? And I have to make up something on the spot." I said, "I don't know. We've been invited to a lot of weddings lately. It's probably just related to that." And, tried to diffuse those questions as much as I could. And then a week later, I proposed, and she says she was surprised. She said she had no idea it was coming. But if you look at how perfectly manicured her nails are for that photo, you'll find that I think she wasn't too surprised. And so that's a big part of trying to figure out, as individuals, what data we give up, what data we put out there onto the internet, and where we drop it. Who's collecting and what they're using it for. These are different ways in which companies track your information. We've all heard of cookies, or at least we've probably heard of cookies. It's these files that are saved to our hard drive, and they can either stay as long as you're on the browser, or they can be more permanent and only removed if you go in and actually delete them. But they're collecting information. They're keeping that information. Web beacons, if you click on an image and it takes you to another link, it's collecting information. Embedded web links, you get an email from a company and you click the link to go directly to the web page that they're selling a product or providing information. That collects information. It might be aggregated information. It might just be telling that company that you clicked it, or someone clicked it, or someone in this time and place clicked it. But it's all information. It all comes back and all combines to form a composite picture. They all share with third-party companies, or they share with trusted third parties one way or another. Some companies, they might not be sharing that information with advertisers. They might not be sharing that information outside of the company unless they have to, unless they're presented with a subpoena or they're presented with a warrant. There are those cases. But they all take some kind of data, whether it be about IP addresses, the browsers that have been used, the device being used, and they use that to form a composite as to who they're interacting with, who that prospective customer is, who that prospective user is. They take that information because we make choices to give it to them. Now you might be asking, well, I didn't make any choice. Well, in every situation you have, in one way, shape, or form, there might be a necessity to learn more about who you're engaging with, learn more about the web services you're using, but we make those choices. And the thing is, with respect to the information sharing, these websites don't discriminate based on content. We've been talking a lot about social media, but there's other websites that share your information. Some of you might not be familiar with this website. It suffered a massive data breach about 3 years ago. And the tagline for AshleyMadison.com was, "Life's short, have an affair." Yeah, not that great. Not something you want to be associated with. Their whole marketing campaign was to market to individuals who wanted to cheat on their spouses. Predominantly men that wanted to cheat on their wives. When the breach came out, there was a dump of all email accounts associated with the webpage, with the website. 15,000 of those emails out of a couple million belong to .gov or .mil domains. People were using their government-issued email address or military-issued email address to sign up for this service. And that's not counting people that use their company emails. So now we've got more information that's out there. More information that not just links to you, but links on your company. It links to who you're affiliated with. And as I said before, all of these indirect identifiers come back to form a composite, to form a picture of who you are. So you might be asking yourself, well, how do I find out who's doing this or why they're doing it? It comes down to the terms and conditions. And yes, they're unwieldy and oftentimes they're burdensome. I know because we did a show of hands of who's read them. I've written them. You think it's tough to read through terms and conditions. Try sitting there and writing them from start to finish. It can be a little burdensome. It can be a bit much. But there's a reason that that companies ask lawyers to do that. Not just to protect the company, but this is a contract that the company signs with you. And with that, you make certain representations about how you're going to collect the information, how you're going to use that information, and who you're going to share that information with. The bad policies are vague about how they do it. The bad policies are vague about where it ends up going. And if challenged, if there's a breach, or if there's a security incident, or if there's an allegation of misuse, those are the policies that the hammer comes down hard when faced with a state attorney general or with a regulatory agency. The good policies that are short, that are clearly written to where someone with a 6th grade education can understand and can read it with terms that are actually defined. You hear a lot about cookies. The good policies define what a cookie is. And even better, I often counsel clients to put in a link based on the browser that the user might be using, whether it's Mozilla, Chrome, Internet Explorer, Safari, a link to how using that browser, they can turn off cookies. How they can have cookies just never download in the first place. It's making those tools readily available. It's making those decisions that the user makes easier. Now, to be fair, yeah, by disabling cookies, you might not be able to use some of the services from that website. That's the website's prerogative. That's their choice, just as you have a choice to go elsewhere, to take your business to a competitor that's going to be more respectful of your rights or to allow for a better facilitation for you to access the information or access the services that you want without giving up that information. And so terms and conditions, privacy policies, we all know that sometimes they're often hard to find. I'll tell you, usually they're at the bottom of a web page. You'll see a privacy policy, you'll see a terms and conditions page. You can click either one of them, and the privacy policy will give you more detail specifically about the information that's being collected, used, and shared. The terms and conditions will set forth your rights and the rights of the company in terms of what you can do, what you can't do. It puts you on notice. And I know what you're saying. Zach, I don't have time to read through all of that. I don't have time to do that. I understand that. But that's just the cost of doing business. And a big part of that is empowering yourself to understand your rights. Right now, oftentimes, we use that as a resource after the fact. after we think we've been wronged or after we think that we've become the victim of identity theft, then we turn to the terms and conditions and figure out what our remedies are. That's still okay. There's nothing wrong with that because it sets forth what you can or cannot do and how you can redress. So these are tools that are available, and they tell you important information. You'll remember a couple summers ago, the Pokemon Go app was launched. And all of a sudden you saw people outside in the summertime. Shocking, I know. But they were going out on their mobile devices and playing this game, and it wasn't until about a week later that this news story broke about the information that the mobile app was collecting and sharing. But it was right there in black and white, specifically, because you must have an account with Google, the Pokemon Trainer Club, or Facebook. Before registering to create an account, we'll collect personal identifiable information, such as your email address, your PTC registered email address, and or your Facebook registered email address, that your privacy settings with Google, PTC, or Facebook permit us to access. And registering a PTC account will require you to submit the date of birth of the user, which could be you or your authorized child, and the PTC username. The information will be shared with us. See the Accounts with Children paragraph below for more information on this. It was all there in black and white. Same thing with Facebook and Cambridge Analytica. The ability to share that information with a developer that is using the Facebook software to be able to log in with the app using Facebook, all the information was there in that policy. The problem is that Facebook didn't live up to their end of the bargain. They made representations about sharing that information and who they would share it with, but once they shared it, that third party broke his agreement with Facebook and gave it to another third party. And so at that point, the question becomes, to what extent should Facebook have been enforcing their terms and conditions? To what extent can they enforce those terms and conditions? You can have a great policy. You can have a great product that's smart, that's innovative, that's groundbreaking. But if you don't police who you do business with, if you don't police how you manage that information, then you get the negative publicity that comes following an abuse. And that negative publicity can sometimes result in lost profits. It can result in disengagement from customers. It could mean the end of your business, or it could mean a hiccup, depending upon how you react and how you address the issue. And so another example, terms of service with WhatsApp. We see them everywhere, but the question becomes, to what extent are both sides of that agreement following through on their obligations? So any privacy law that you see, in some way, shape, or form, and I put privacy law in quotation marks because there's no omnibus privacy law in the United States. There's one in Europe. There's a regulation that applies to all data, regardless of where it comes from, what it relates to, as long as it relates to the individual. But in the United States, we have a patchwork of data laws. Some that deal with protected health information, healthcare information, some that deal with financial information, some that deal with any computerized information. And so all these privacy laws, in some form or another, will provide you with an opportunity for notice, to give you information about how they're collecting, storing, using, and sharing your information, choice and consent, the ability to make decisions based on the extent to which you want to share that information. And sometimes the answer is, if you don't want to share it, don't use the service, don't use the product. Access. To the extent possible, individuals should have the right to review their personal information to ensure such information is accurate. Security. Commercially reasonable means should always be used to make sure personal information is safeguarded against unauthorized use. Enforcement and redress. If the privacy policy is violated, how can it be enforced? How can the user find redress? And then minimal use and limited use. That you're not going to use that information beyond what you say you're going to use it for. So I'm not naive. I understand there's a lot of companies that are saying one thing and doing something completely different. And that's why we have enforcement actions. That's why some laws allow for a private right of action so that you can sue directly. That's why you can often raise a complaint. You can file a complaint with the Federal Trade Commission or with the State Attorney General to where they will go in and investigate that company and see if they're committing an unfair or a deceptive trade practice that can make them liable to thousands upon thousands, sometimes hundreds of thousands, sometimes millions of dollars in penalties. And what's important to understand through all of this is we'll often hear privacy and security muttered in the same breath, but they're not the same thing. They're two entirely different concepts. Privacy is the ability to determine and control when, what, and to what extent information about you is shared with someone else. Security, on the other hand, is the ability to exercise that control. Put another way, you can't have privacy without security, but you can have security without privacy. And so when we think about our rights, think about within the framework of privacy. Think about within the framework of those fair information principles. And if you're a small business owner, or if you're a company of any size or shape, ask yourself whether or not you're living up to those principles and how you're living up to them. This is just a survey of different privacy laws in the United States, from HIPAA to Gramm-Leach-Bliley to the Fair Credit Reporting Act. I think that we have another session where Sarah is going to go into a little bit more detail about privacy laws and regulations in the U.S., but this gives you a framework for how it's different depending upon the data that you're sharing. And when we think about the harm with abusive practices, you can have identity theft, stolen credit cards, a violated privacy policy, which can amount to a breach of contract, health data abuse, financial data abuse, children data abuse, invasive marketing, when you get spammed, and all of a sudden you can't get out of the plethora of emails you're getting about a product or service that you want nothing to do with. The harm can be fraud, theft, deception, a risk to your reputation, to your financial harm. And the legal response, for just about every single one of those, there's some sort of response, whether it be a FTC investigation, whether it be through the criminal courts, whether it be through a civil action, whether it's filing a complaint with a regulator and getting an enforcement action from HIPAA or the GLBA or COPPA dealing with children's online privacy protection materials. Getting a sense for what your redress is in each of those scenarios gives you that ability to have more control over your information and its use. Another aspect, another angle that I want to go into is biometrics. And biometrics is whenever you have a face scan. You're using a product that registers your face. So if you've got the new iPhone, you have the Face ID. That's a biometric. It takes a scan of your face. Or if you have on your smartphone a thumbprint sensor that you use to unlock your code, that's collecting information that's attributable only to you and using that in some way, shape, or form. In those situations, it's security. And what we're seeing on a state-by-state level is more states are regulating that information because they understand that if you use your thumbprint to gain access to your phone or to gain access to your bank account, that if that information is corrupted or it falls into the wrong hands, the risk of financial or reputational harm far outweighs what you see when a password is compromised. I can change my password in about 70 seconds. Can't change my thumbprint in that time. And so you're seeing with Illinois, they took the lead, but Texas, Washington, they each enacted their own laws that regulate this type of information. And that's why if you use certain mobile applications in Illinois, you're actually physically in Illinois, they won't give you access to that app. In fact, there is a mobile app that Google put out earlier this year. That if you take a selfie, it'll scan your face and put forth a portrait from the Louvre that would match as best they could your face, so you could compare your face to a painting. Wasn't able to do that in Illinois because of this law. Because unless they get affirmative written consent from the user, they can face a fine anywhere between $1,000 to $5,000 per violation. If you think in a class action with hundreds of people joining in, that adds up quickly. And I'll give you a few examples of this private right of action in action. The ability to exercise this law and hold companies accountable for what they're doing. So last year, in a lawsuit, Riviera versus Google, a man was in the background in Chicago of a photograph. That photograph was uploaded to Google Photos. He finds out about it. He finds out that Google Photos takes a face scan of anyone and everyone that's in that photo. He's just in the background. There's no name attached to it. There's no nothing personally identifiable other than his face print. The specific contours that make his face different from your face, or my face. He brings forth a lawsuit against Google saying they violated this law in Illinois. They never got his consent to be able to do that. They never got his permission to be able to do that. And this litigation's still going on. It's been going on for over a year, fighting Google because people joined into this class action. Because this could amount to millions of dollars in fines and penalties should Google be found liable. And right now, Google's lost every motion they filed to try to dismiss this lawsuit, to try and get rid of it. It might end in a settlement. It might not end in a verdict, but you better believe that these types of actions deter Google from further uses like that. That's why you saw the Google Arts and Culture app that took your face print and compared it with a painting. They didn't do that in Illinois because they knew this can come. Another example, it's a lawsuit called Vigil versus Take-Two Interactive Software. There's a video game, I think it's NBA 2K16, that allows for players, if they're playing on Xbox or wherever, to upload a picture of themselves and it'll digitally imprint upon the 3D character. So instead of being like Mike, you could be Mike, right? You could have your picture over Michael Jordan's body or LeBron James' body. Class action lawsuit when two gamers figure out, hey, we put our photo up there, but they never asked for our consent. So we can take this company for a ride. We can sue them. Because under Illinois law, you have to get explicit written consent. The court dismissed that action because of the choice. They found that, correct, the company did not get explicit written consent, but these players uploaded their photos knowing that it would then go onto the internet, knowing that in order for the product to work, it has to take a face print and be used within the game. And so even though there wasn't an explicit written consent, by virtue of the player's choices in putting that information up there, they effectively gave that consent. So once again, the courts look to the choices that you and I make. Last example, one of my favorites. This doll is banned in Germany. It is considered a risk to families. That's what the German government issued a press statement. And they will fine any family up to 15,000 euros if that doll is in the house, if you own that doll. And you might say, why? It looks innocent enough. It looks fun. Well, that doll has a voice interaction system that allows you to talk to the doll. You can say whatever you want to the doll, and the doll will talk back. It's got an information collection system similar to Alexa or Siri. And so the doll might ask, where do you live? Where do you go to school? What do your parents do? Do you like soda or do you like milkshakes? Where do you like to get milkshakes from? And it collects that data and stores that data on a server. And right now, Nuance Communications and Genesis Toys are engaged in an investigation from the Federal Trade Commission because under a federal law called the Children's Online Privacy Protection Act, if you collect information from children under the age of 13, you have to get that parent's explicit written consent. And the problem was that the way they are getting that consent was in order to use the voice recognition technology, the parent would have to go onto a mobile app, download the app, and submit an answer to a question to show that it was an adult operating the app. The question was, what is 9 plus 7? Now, I know our education system's not the best in the world, but I know a lot of 12-year-olds that can answer that mathematical equation. And so, when the FTC got wind of this, they looked to the terms and conditions. And guess what? It was misleading with respect to how the information was being stored, that it was being collected and kept on a server to be used by Genesis Toys and Nuance Communications. Nuance Communications, which also has contracting services with the U.S. Department of Defense. So this company has already been banned in Germany. It's on a consumer watch list within the rest of the member states of the European Union. And you can't find it in stores because it's in the middle of an FTC investigation where that company can be fined millions and millions of dollars based on these violations. So this is how we hold companies accountable when there's an abuse. Here, a choice was made, and the information that was given about the services wasn't transparent, it wasn't accurate. So this is the redress. This is the way in which you hold that company accountable. As we're wrapping up, when I counsel clients, I often tell them to do a privacy impact assessment from the very beginning if they can. They have a product, they want to get it to launch, and I have them go through and step-by-step identify what are the privacy risks. How are you going to collect this information? How are you going to use it? How are you going to share it? And at each step of the use of this product or service, what are the risks in which that information can get out? Can be improperly disclosed without the user's consent. Inventory that data. Get a sense for what the risks are, and then address the risks through the research and development stages. Make an informed decision, for instance, about the introduction of biometrics, what we just talked about. Is it right for your product? Is it right for your service? Or are you best using something else? Weigh the benefits and drawbacks of using a biometric. Great for security, not so great if that information gets into the wrong hands or can be spoofed. Choosing what the right types of products and services are in order to minimize those risks. And when you do that, if you're a company that engages in this practice and an incident occurs, that's something I didn't get a chance to explain. You'll hear a lot about data breaches, right? You hear about it in the news. That's my word as an attorney. It's not yours. Because breach is a legal term of art. It means something different in every state. And right now there are 50 different state laws that regulate what happens when a breach occurs. So if you're part of a company, you're part of a business, you own a business, and you think you've been hacked or you think your information's been improperly disclosed, don't send an email to someone saying, oh my God, I think we've been breached. Because a litigator is going to tap into that and say, later down the line, if you're facing a consumer class action, hey, they were on notice that they were breached and they didn't do anything about it. Instead, you have an incident. You have an issue, a concern. And you call up a lawyer, hopefully me, I have business cards if you like, and you get a legal opinion. Because, for example, if you've been hacked and the information they acquire has been encrypted, in every state in the country, that doesn't constitute a breach. The government said that the risk of harm is too low for you to provide notification. So you don't have to put yourself at reputational or financial harm by disclosing improperly. And so that's what this is with a privacy impact assessment. Getting a sense to where if you have an issue like that, What's the best recourse, and how can you safeguard that information properly? Last but not least, privacy by design. It's the same idea, only in addition to an assessment. When you have a product or service that you're putting onto market, getting a sense for how you're going to safeguard the information you collect from top to bottom. Oftentimes we think about privacy as something that we do at the very end. Oh my goodness, we didn't think about privacy. We need to tack something on. This is taking an approach from the very beginning and implementing safeguards, whether it be administrative, technical, or physical, to make sure that information is protected. I've got a startup that I'm working with right now. He wants to go launch in 2 years. He's thinking far ahead. But he calls me because he understands that he's delving into very sensitive data, and he wants to make sure he does it right. So he's putting an investment in legal counsel very early to make sure that every step of the way on this product and service, he's implemented privacy everywhere. And in California, they passed a law last year that mandates any mobile app that connects to the internet have some sort of documented analysis that they've taken a privacy by design approach. So to wrap up, and I'll be happy to take questions, as we think about transparency, there's an uneven distribution of power, right? It's the individual against the company. And companies have a lot of power because they're the ones that are providing the service. So they can dictate the means by which that service is given. The twist, though, is that as a consumer, you have multiple options. You can either not do business with that company, find someone else on the market that will treat your information differently, the way that you would want it to be treated, or you can find the laws and the regulations that govern that company and make sure that you hold their feet to the fire, whether it be through complaints, whether it be through exercising your rights in the terms and conditions or under the privacy policy, or if it gets to that stage, initiating a lawsuit and defending against a lawsuit. So those are my thoughts on the subject. I'll stick around for a few minutes if anyone has questions, but thank you very much for your time. I appreciate it.